Oh, you only have a roll.
That's right. That's what it is. Pigs out the dice.
So, anyway, and then Nick can give it to you in digital form if you find it more useful that way. So I do have 7 o'clock. So I leave it. You have some other items first, I think.
Have heard from Mr. Tony? I have not. He did say he would be in attendance. So he will wait 2 or 3 more minutes. Okay. We'll go to 3 after.
He has this document. What I have in this document.
Oh, probably so. I've done this before.
Call Mr. Tony.
Hello, Mr. Tony. Nice to see you, sir.
If you want a donut.
Oh, appreciate you, man. I just left the job, man. Came here. We talked to dinner.
Oh, thank you.
Yeah, I think dinner. I know.
On your mics, because this is going to be recorded. All right, good evening. I'd like to call our meeting to order. Today is September 28th, and it's just after 7 o'clock in the evening. Quick roll call, Mr. Thornburg.
Thornton.
Thank you, Mr. Thornton. Apologize. Mr. Borka.
Present.
And Mr. Tony.
Present.
And Mr. Turner. Okay, we have all members of the BZA present. Next, I would like to ask to the agenda to be adopted. If you would, please take a quick moment to review it. And I need someone to make a motion.
I'll make the motion that the agenda be accepted as it is.
Okay,
I second.
very good. Any discussion? All approved, all in favor?
Aye.
Any opposed? Okay, and then the minutes. Have you had a chance to review the minutes? That was sent out last week, I believe. And we had a chance to review it. Did you have a chance to review the minutes?
I did.
Okay. Okay, can I get a motion to approve?
I make a motion, we approve the minutes.
Okay, any discussion?
second the motion.
Second.
Okay. Any discussion?
Nope.
Okay. The minutes are approved from the last two meetings. Oh, how about a vote? Those in favor of approving the minutes?
Aye.
Aye.
All right, opposed? Very good, thanks. Now we have a treat tonight. It is training from Ms. Pandak on the roles and responsibilities of the BZA.
All you.
Wow, thank you. As Mr. Thornton has already called me out, I have given this presentation before. And I think it is a useful one. I hope you will find it that way. In many ways, it is an overview. Not only am I going to cover your statutory roles and responsibilities, I'm going to give you a little bit of legislative update. Not a lot happens with BZA legislation every year, which is a good thing. And then talk about some Supreme Court cases that are relatively recent that may give you some feeling as to what the court's thinking about the BZA. I didn't ask you, Nick, how am I rolling this forward? Did I just tell Ricky what?
Yep.
Okay, Ricky, if we can move to slide 3, please. There we are. Thank you very much. And then we'll have questions at the end, but as I was indicating to you all earlier, if you have questions as we go along, I'd be glad to answer them. If they get into kind of a long one and looks like it's really going to take me off track, then I may ask you to talk about it at the end. Okay, slide 4, please. Okay, the BZA has a quasi-judicial role. We've joked from time to time with different BZAs that you ought to have black robes when, like judges, when you are acting in your role with respect to appeals and variances. But your quasi-judicial role comes, as you know, from the fact that you are appointed by the court. That's not true of all officials. You have the authority to make binding determinations in certain cases, much like a court would. And then because you have quasi-judicial authority, you also have the responsibility of due process to the parties that come before you. And so we'll talk about what that means in a more specific way. Next slide, please.
I have a question.
Sure.
To what extent can we vary from the rules that are already in apply? If we have certain powers and discriminations, what rules can we change?
Oh, we'll talk about your bylaws. That's about the only thing you can change. So we'll get to that, but you have the ability to create your bylaws, but you are governed specifically by statute. And for your reference, you would look at 15.2, 2307, and going forward, it talks about the BZA 2308.1, et cetera. That whole section is what's going to be your guidance. I assume everybody knows this, but you can go onto the website, put Code of Virginia in, and you can include the statute number and pop it right up, and then be able to follow that whole course of statutes.
I knew that. I just want to make sure everybody else is on the same.
Yeah, we'll get to the bylaws, but you're governed by the constraints of the statute. This is not relevant to you, but my reference to wearing black robes, those BZAs who have legislative authority, we also suggested that they would take off their black robe when they were exercising their legislative authority, so everybody would know, and they would remind themselves that they had changed the type of authority they have. So, but that's not an authority that the town council has provided to the BZA. You shouldn't feel like you've really been deprived by them, particularly because only maybe half at most of the BZAs in the state have those legislative authorities. Let's turn to the next slide, please. The authority that you do have, we'll have appeals, Variances, special exceptions, that's the legislative authority. And then zoning map interpretations, probably something you hadn't really thought about. We'll talk a little bit about that later. And I think I've only seen one of those in my entire career that actually materialized. Next slide. Oh, we have it. Thank you. The last major General Assembly amendment of the Board of Zoning Appeals statutes was in 2015. And you kind of go like, how's that relevant to me? Well, we're going to talk about some of the changes that occurred then because the Virginia Supreme Court hasn't really had to rule on cases that dealt with those changes. So there was a huge dispute at the time about the basis for the changes, which in fact were based on some decisions coming down from the Virginia Supreme Court. And then the nature of what the actual changes were made by the General Assembly. And then everybody kind of said, wow. Some of us said, not much change. Others said, see change. And there just haven't been any court opinions on it. So they remain out there even, 7 years later, still perhaps some lack of certainty. I don't think that's going to be a big deal for you all because I'm going to tell you how I think it hasn't changed much and the reasons why, and then you'll just wait. And at some point in the future, somebody may give you a different opinion. Next slide, please. First, let's talk about appeals. 15.2, 2311. You have the responsibility to hear and decide appeals from zoning administrator decision. That you pretty much know. But you also have the authority and power to hear and decide appeals from any order, requirement, decision, or determination made by any administrative officer of the locality. And a lot of people just don't think about that. And those aren't all that frequent. Maybe I'd say 20% of what I've seen, when people raise it, but they can come to you. You have to give notice and hold a public hearing, and you have to base your appeal on the judgment of whether the administrator's decision was correct. We'll get into more depth on that. Next slide. So the statute says the types of things which can be appealed. The meaning of a regulation in the zoning ordinance, the zoning classification or whether a use is permitted, structure, proposed or existing, and compliance with regulations, and then issues of vested rights, which are probably some of the more common ones that come before you. Next slide. The person aggrieved by a determination has a right to appeal to the BZA. Well, that means not everybody has that right. They have to establish what is called standing. Are they in fact determined to be aggrieved? And while the Supreme Court has been a little bit more flexible on that issue of aggrieved in recent years, it's still standard that is in there that you have to look at. If the appeal is not timely filed, then that decision by the zoning administrator or administrative officer is a thing decided. So if that 30-day period after when the decision is rendered is very important for the landowner or developer.
Can I ask a question?
Sure.
So the BZA makes a decision. The person on the other side does not contest that decision. However, the BZA's approval is not following what the BZA is allowed to actually make approved. Does that come up in court some way? How is this?
Sometimes. The 30 days I'm referring to is from the time that somebody like Nick
Right.
makes the determination and somebody has to appeal that, somebody who's aggrieved, to you as the BZA. With respect to the issue of somebody appealing a decision of the BZA, you say, okay, nobody appealed it. What if it wasn't done properly by the BZA?
Right.
It's the BZA's decision would stand.
Okay.
So unless somebody who has a right to appeal brings an appeal, if you didn't follow your process or something else, it would stand unless somebody challenged it.
And how
That
long do
doesn't,
they have,
what?
how long do they have before they can make that challenge?
30 days from your decision. So, okay. let's turn to the next slide, please. Oh, I'm sorry. Yes, we're good. We're moving on to slide 11. Ricky, I'm sorry. I was flipping back and forth. Thank you very much. Your authority is limited. Again, it's limited by statute. You cannot determine what are appropriate uses within a zoning district. That is a legislative decision. So you can't say, oh, we think that really ought to go in this district, not within your purview. You can't decide what's in the public interest. Now, you may find that offensive when I tell you that. Certainly, people come to me as a town attorney or county attorney, as I've been from time to time, and say, you were acting in the public interest. And I say, oh, no, my client is my board of supervisors or my town council. Now, I am presuming that we are all acting in the public interest, but I do not define public interest. So you do not, as the BZA, define public interest. You don't have the power to decide whether a zoning regulation is valid. And you don't have the power to amend or repeal a zoning regulation. We'll talk a little bit later on if you have concerns about these things, what you might have as alternatives. Next slide, please. On appeals, you can reverse or affirm, and you can do it in whole or in part. And sometimes we look at things as being just all one way or all another way. But you have to have a concurring vote of majority of the BZA membership to reverse a decision of an administrative officer. And then the appeals would be to circuit court, so over Manassas. Next slide, please. Here's your sort of crib sheet on decision-making requirements. And one of my goals, even though some of these slides may be repetitive, I thought it might be helpful for you going forward if you wanted to just go back and look at something and say, what is it that I have to look at? That you could put on a slide and it kind of categorize and state specific information. So that's part of my goal here, even though I will be in sometime I'll be a bit repetitive. I'll try not to be too repetitive, but I thought it might be useful for you to have something that you could use as a reference point later. So you look first to Virginia law. The zoning administrator's decision is presumed correct. Always start with that. And sort of obvious reasons. Persons like Nick, Cicero, are charged with the administration of the zoning ordinance. They do it all the time. They do enforcement. So both the General Assembly and the courts say you should give a presumption to their decision being correct because they're kind of in the mix all the time working on these matters. The same is true with other administrative officials. For example, if there was an appeal of a decision made by Joan A. Prevost-White as Public Works Director to you, again, it would be presumed to be correct. Also important is the consistent interpretation of a zoning ordinance provision or a regulation by the zoning administrator. We all, consistency is important for everybody to have a stable understanding of what's going on. And so it's entitled to great weight. And you should consider and give it great weight when matters come before you. So you look for the consistency, not just of the current rulings, but if they are identical or very similar rulings made by past officials in that same position, you would want to look at that and look at consistency as well. And I hesitate, and I tell you, looking at past officials, you want to look very carefully and make sure it's the same situation and not that they're diverse facts. Importantly, the statute provides, and it's not just because Nick is diligent in his work, that the zoning administrator is required to explain the basis for their determination to the BZA at the hearing. So can't just say, I made this determination. They've got to provide the basis. That's also good because it helps establish the record and everybody understands sort of what the reason was on the record. Let's go to the next one, please, Ricky. Determinations as to vested rights. And these are some of the thorniest issues that we deal with, me as town attorney, Nick as zoning administrator, and the BZA. They're highly fact-specific, and oftentimes the facts are not always clear. And so it requires a lot of probing. So the vested rights used to come from what was called the common law. There was not really there weren't court decisions on it. There weren't statutes. You would look to things like, what did they do? Did they do enough to get a right to this development to proceed? It then evolved. Common law also includes case law. So cases, determinations by the Virginia Supreme Court, maybe as to other courts that might have some precedent. But the General Assembly has actually codified what it believes constitutes a vested right in 15.2-2307. And I encourage you, anytime you have a vested rights case, to go and read that statute. It's not an easy read. I feel like it's that one where you say, you put your finger in here and you have this fact and you have this fact. So you might find yourself actually doing, but they don't do this anymore, I'm sure, but my English teacher used to make us, break down sentences.
Yeah.
And so that's kind of the thing that you might find helps you figure out whether they're meeting the requirements for vested rights. 3 key factors. A significant governmental act. What might those be? It might be a rezoning, might be approval of a subdivision plat that's recorded, might be approval of a site plan, but it requires first a significant governmental act. Sort of distinguishing it, somebody who just files a site plan and does nothing more with it doesn't have a significant governmental act. And actually, I'm working on some litigation that involves things that relate to that. Good faith reliance. They have to have done something in reliance on the fact that they had this governmental act. And then extensive obligations, substantial expenses, and diligent pursuit. So for example, I had a case I handled some years ago for Spotsylvania in which they had a significant governmental act, they had approval of a subdivision plat. It was 14 years prior. And nothing had been done on the section they wanted to move forward with. Section 1 had been built, but that had been long completed. So section 2 was the one they wanted to move forward with. And we were successful in convincing the court that they had the significant governmental act, but they hadn't really relied on it because they hadn't done anything for years. And then they'd had no extensive obligations that they'd incurred with respect to this section 2 as opposed to section 1. But again, these things can get dicey because if they constructed the sewer from section 1 all the way over through section 2, 3, 4, whatever, there were multiple sections, and they constructed the roads onto those other sites, then the issue might have been very different, as opposed to basically having essentially the ground looking the way it did 14 years prior. So that you have to have all 3 of those things, not just one. Next slide, please. Let's talk a little bit about variances. Variances are truly a creature of statute. And if you ever want to test your memory, try to memorize this definition of variance. I can't, so you all would be better people than I am. But what it is a reasonable deviation from those requirements that otherwise exist. But they've got to be specific requirements. They have to relate to shape, size, or area of the lot. And I'm going to skip through this, or size, height, area, bulk, or location of a structure. When the strict application of the ordinance would unreasonably restrict the utilization of the property. What does that mean? We're going to get to it in a second. And importantly, the need for the variance would not be shared by other properties in the area. And I'm going to give you an example in a moment. And the variance cannot be contrary to the purpose of the ordinance. So it can't be kind of an end run on trying to get rid of an ordinance that somebody doesn't like. And it can't include a change in use, which could be done by coming in for a rezoning or a conditional zoning. And so let me give you an example from another community that went up to the Virginia Supreme Court, came back down. It's been the General Assembly a couple times because one of the parties is represented by a legislator. And it involves a property in my hometown of Stanton and the wall. And so they're on the street in Stanton, the zoning ordinance allows the construction. Hello, how are you, Councilwoman Miles? That's okay. Nice to see you. So there's the zoning ordinance allows a wall, and it allows a wall that is of a certain height, relatively low height. And a lot of people in neighborhoods have this wall. Well, this one person comes in on this elegant old house and builds a very big wall. Now, there are questions about whether they got the right permits that are separate issues, but they build this very big wall and they build it to dimensions that are not allowed in the zoning laws. So they try to come through and they try to get a variance. Well, if they can get a variance, none of their neighbors can, and their neighbors have walls too. So it doesn't meet that requirement of not be shared generally by other properties. And this battle literally went on for over 10 years, back and forth, about whether the wall was permitted legally under the zoning ordinance, whether the BZA took the proper action with respect to it. Went before the BZA, I think, a couple times. Went before the Planning Commission. It was probably a headache, is probably as much a description of it as a variance. But it got into all of these issues about, was it a reasonable deviation from the size that was allowed? Was it a reasonable deviation from the shape? And so I will describe for you what I think is the purpose behind where this definition is intending. As a matter of law, even constitutional law, if there is a taking of property in which the entire economic use of the property is lost due to a regulation, and I'm not talking about a taking to widen a road, I'm talking about a regulation applying it to a piece of property, then that person may have a right to sue the government or sue the government for compensation. Okay? So the purpose is to deny complete economic use. Now, when you think about that, that's very hard with a piece of property. And what you normally hear, and Mr. Borker, you may hear before the Planning Commission times, people come in and they go, that's a taking. Well, usually what they mean is they can't do what they want to do. It doesn't mean that they've lost the entire value of their property. And where I think this came from was to try to codify what was case law, basically saying you have to prove that the value of your property from an economic standpoint has been taken away. And there was a case just prior to this current version of the legislation called the Cochran case, in which the issue came up about what constituted a variance, what could qualify as a variance. And in fact, the court basically reached that conclusion that you had to have almost a complete loss of economic value. So not intended that people could get variances very easily. That was the whole goal of it. Because if everybody could go get a variance for it, then you should change the ordinance.
Yeah.
You should change it because there's something wrong with it if you're telling everybody they should go get a variance. So that, and once this legislation was passed, it came in the wake of the Cochran case, and those legislators who proposed it felt strongly that the Cochran case was wrong that it shouldn't be such a tough standard. You should be able to get a variance a little easier than that. But the ultimate language, I think, and again, this is an example where in basically 7 years, there's not been a case that has come from the Supreme Court that has clearly articulated whether or not the standard in Cochrane still applies or whether it's a new lesser standard. But our view has been, and my personal view, having studied it for a while, is that it's still basically the same standard when they talk about unreasonably restrict the utilization of the property. It's not just you as a landowner are disappointed you can't use it a particular way. So let's go to the next slide, Ricky, please. And this goes further and talks about applying the definition of variance, which is what I just gave you, in the context of what a BZA determines on variances. And again, it talks about alleviate a hardship by granting a reasonable modification of the property or improvements thereon with respect to a person's disability. And I want to call this out because it kind of cuts against that what I told you is loss of almost entire economic interest. There's a special case that it talks about here for those persons that have disabilities, and that's consistent with where the General Assembly has, in a number of places, including in zoning area, has given a greater, I call it accommodation, not just for disability, but has given a greater consideration and flexibility to uses that involve people or assist people with disabilities. So it's kind of consistent with that. But the rest of this statute with respect to variance has the same language about, if you'll notice, like maybe 5 lines down, alleviate a hardship due to the physical condition. And I'm sorry, 3rd line down said would unreasonably restrict the utilization of the property. So it's that same sort of, you've got to show something more than, a lot more in my mind, than just the person can't get the use they want. So, and then the other thing I should note, my little star at the bottom, that variance can expire when the person with a disability no longer needs the modification. So one of the things you should bear in mind is that if you to grant variances, you can impose conditions. You can require a bond depending on what the nature of the development is. So it's sort of things that perhaps you haven't normally thought about, to Mr. Thornton's comment of how far can you go? Those are statutory permissions. Let's go to the next one, please, Ricky. You're required to notify the Planning Commission, and just because Mr. Bork is on it, it's not his responsibility. But you might work with him, delegate that, or the chair can, and I think the easiest way is to do what the statute says and have the zoning administrator send a copy of the application for a variance to the Planning Commission. Important reason, when we talked about, it has to be a condition that's not generally felt within the area around it. It can't be a change of use. Those things are not normally matters that you as the BZA would see, but they're quite commonly things that the Planning Commission would see. And that's why you're to solicit the Planning Commission, or at least tell them about it if they want to send in a recommendation or appear as a party. And I've seen both occur, both in writing or actually having a member of the Planning Commission, if the matter is significant enough in the Planning Commission's mind. I don't want to suggest, Mr. Borka, that the Planning Commission has to do something each time, but it could choose to do so and set up a process for that. Let's go to the next slide, please. You can't have the variance be of substantial detriment to adjoining property. Obviously, it wouldn't be a minor deviation then. It can't be general or reoccurring, so that make a general amendment reasonably practicable. I give an example. Years ago, the Prince William BZA was getting a lot of requests for variances on decks. And it was, I say a lot, maybe it wasn't hundreds, but it seemed like it. And the BZA is like ready to just go crazy because it's not another deck variance. And one of the things, and they had to follow what the ordinance was, and a lot of the applications simply were just, we want a bigger deck. So in the annual report, I think that was coming up, I recall it as being part of the annual report, the BZA decided to advise the Board of Supervisors that they might want to take a look at their ordinances related to the size and construction and location of decks, because there appeared to be some general concern. And maybe somebody ought to take a look at it and see whether it was a reasonable requirement. Not surprisingly, the Board of Supervisors made some modifications to the deck requirements following that. But that's an example where the BZA was supposed to follow the law. They were following the law. They denied a lot of variances. There were a lot of unhappy people. But they advised the Board of Supervisors, who otherwise might not have been following the BZA and actions, and that here was something that maybe you should take a look at. And I think that's an effective way if you find that, since you can't change ordinances or regulations, if you find that you're seeing a pattern that suggests that the ordinance ought to be looked at, that might be a good way to suggest it. Okay. I mentioned already, you can't allow non-permitted use or zoning classification change. And you can't do it if they can get an SEP or a zoning modification. And let me just digress a little bit to the issue of zoning modifications. There's a provision in the statute that allows localities to give authority to their zoning administrators to grant zoning modifications. And we might call them like mini variances. In fact, they would be like variances. The standards are almost the same. And as I recall, Nick, the town has not given that to you. And many zoning administrators candidly don't want it, that authority, because it puts them in the very awkward position of doing what you all would have to do after you go through due process and everything. They would have to go through due process. They have to take public input, and it's a great burden, I think, in that regard. And then when the zoning administrator renders the opinion, it may be that nobody's happy. And so it goes through the process again. Okay, next slide, please. Have to have a public hearing. You have to have a concurring vote of majority of the BZA membership. As I mentioned, you can impose reasonable conditions and require a bond or guarantee. Next slide, please. Key principles. And again, this is one where you might pull out if you end up with an variance looking at the types of things. They should be granted only to achieve parity with other properties in the district. They should be granted sparingly. They're not intended to be handed out like candy at a parade. They run with the land, not with the owner or the applicant. So once a variance is granted, it runs with the land. And as I mentioned to you, the variances with respect to persons with disability can expire and be gone, but otherwise they would continue. Each case is considered on its merits. It's not a precedent. And if there's an existing reasonable use of the land, a hardship does not exist.
Oh, excuse me.
Sure,
Does any of that expire, the running with the land? That's in perpetuity?
that's correct. Yeah.
So
Now, where it may end up being kind of overruled is if the land was rezoned, then the variance might have no relevance. So,
one of the reasons I asked that, because in one of our last cases, a variance was granted to a piece of property, which we just learned is not going to be actually with that owner anymore.
mhm.
And it seems that variance could then extend forever.
I'm not going to render opinion on that one because I haven't been asked to look at it yet. So,
Okay.
but certainly that's one thing you need to consider when we're considering granting a variance is it's going to run with the land. Okay. Next one, please. You have to have a quorum present. That's obvious, and we already talked about concurring vote. Let's turn to 22. Ricky, next one. One of the things, and I'll talk about this mention on appeals as well, sometimes, not always, and sometimes and most of the time it's inadvertent. People will appear before you and they'll tell you some of the facts. And they won't tell you all the facts.
Mhm.
And sometimes, many times, I should say, it's because they've just forgotten. Sometimes they may not want you to know all the facts. And then once you make a decision, they may be unhappy and then they appeal to the circuit court. And suddenly they have great memory on all these facts that they didn't tell you. That's really hard on the circuit court because the circuit court's supposed to give some weight to your determination as a BZA, but now they're getting new facts. So I think it's a good idea as part of your process on variance and appeals for you as the chair, Mr. Turner, or someone else in the BZA to say, have you provided all of the evidence of which you're aware of at our hearing tonight? And that doesn't mean that everybody's going to, remember everything they're supposed to, but it makes it clear, not only to the person you're saying that to, but it also makes it clear on the record for the circuit court that you have tried to make sure that you did the best possible comprehensive job as a BZA. And the matter still ended up before the court. So I suggest that as a good way to, a good process to include. Can I go to the next one, please? Now I want to talk about some of the due process issues, and these all came in as part of the revamping of the statute in 2015, some of which to me were obvious, but maybe not obvious in all the BZAs across the Commonwealth. There are specific provisions with respect to ex parte communications. And that means talking to one party in the case without the other party being there. And the statutory provisions discourage that. So what they say is you can, but you can't discuss the facts of the law relative to the particular case. So for example, you're out at the gas pump and the landowner comes up to you and starts telling you, and you know the landowner, this is a small town, you often know the people in the area. And they say, hi, how you doing? What's going on? How's family? All that. And then, oh, by the way. And once they get to the, oh, by the way, did you recall that I have a variance coming up before you? At that point, you used to say, I'm sorry. I need to have the other party present if we're going to talk about this. Or if you do, you have an obligation to tell the other party as soon as possible what you're going to tell me now. So, and then that puts a burden on you, in terms of your relationship with the other members of the BZA and the transparency with the public. I mean, I would end, if I were in your place, I would end up saying at the next meeting, I'm sorry, I had this discussion and I hope, whoever the other party was is aware of that discussion, has been told. So the easier thing is to just say, do you know that there's this rule? Maybe a lot of people don't know what all the rules are. They're just figuring they know you and you're at the gas pump. And it doesn't apply to any attorney-client communications that you might have with an attorney who might be assigned to help you. Sometime I'm called in around the state to be counsel to a BZA on a matter because it's a particularly thorny matter or it's got high public visibility. It wouldn't apply to those conversations, but it would apply to my conversation with you if I came in and I was representing Nick on a zoning matter and I started talking about the facts of a particular case, then I would have an obligation to go tell my opposing party. And I do recall, I won't mention the case, but within the last year, there was a matter that came before you all, and the opposing counsel did tell me that there was a conversation, and so I appreciate it. That's the right thing to do. The easiest thing is to just avoid those conversations. So there's also a requirement, and this is irrespective of whether the person comes up and talks to you, that any material that's got to be shared, that is material coming in support of a variance or an appeal, any other documentation has to be shared with the other side within 3 days, business days. Next slide, please, Ricky. So 3 business days, and they're available for public inspection. So it's, again, it's a very important issue of transparency. Importantly, though, I'm going to go to statutory rules and amendment. If you're in a BZA meeting on the matter and parties are talking in different parts of the room, there's an obligation for them to kind of be mindful, and if there's a conversation going on that relates to the matter. Again, in this room, it's small enough that you would readily be able to know that and see it. And if I were representing one party and a person X is over there representing another party, and I go walking up to one of you as a BCA member, they're probably going to be following me. So, but, so I think that the exception with respect to being at the hearing and in a public forum is a reasonable one, because it allows everybody to pretty much be aware of what's going on. So other statutory rules, I mentioned already that the zoning administrator or the administrative officer has to explain the basis. Termination is presumed correct. And the appellant has the burden of proof, either to prove that a variance should be granted or to rebut the administrative decision appealed. Next one. Zoning map interpretations. This is the oddball one that I've seen very seldom. Typically, it goes to the zoning administrator, and then appeals go to the BZA. And then if there's no zoning administrator, then you have initial authority with respect to zoning map interpretation. So it would be like, what are the boundaries of that particular zoning district? And you're seeing fewer and fewer of those now. When in the long ago and far away, before I was county attorney, there was zoning that was done. It looked like a child with a paintbrush. And I don't know if you ever had a chance to see those historical maps, but it really does look like, sometimes it looks like a crayon. And so they're like the blue line up Route 1. And you go, okay, well, where's the zoning on that? Where's the line? How does it match with the property boundary? So that's the zoning map interpretations. You see less of that now just because GIS and other applications are done more specifically. Okay. Yes.
Going back to the previous slide.
Can you go back, Ricky, one? Yes. Okay.
The part that speaks, that final
The appellate is,
burden of proof
yes.
to prove variance or rebut administrators.
Mhm. By
That should be
preponderance.
something concrete, I would think, as opposed to something anecdotal.
Yes, when they talk about preponderance, the evidence, it
Yes.
says preponderance, the evidence, not just, I like this more.
Right. He
So-
comes in, says, he got another person with him saying, that's verifying his story, but there's no concrete information, no tax records.
I think you have to really scrutinize that, because sometimes oral testimony is all there is. And if they can link it with enough facts, then you may be satisfied with that person's testimony. But if it's just, oh, I kind of think it was like, maybe 10 years ago, I don't know, maybe it was 20, then you evaluate the credibility and credibility in the sense of, are you getting detailed enough information to make a decision? So I can't say categorically that oral testimony alone is not enough. You want to value what is that person saying and is there enough specificity to it?
Right. But
Can
if,
I'm sorry.
but if this person, there should have been some other kinds of concrete evidence that they should have been able to present to us to verify this.
And you certainly could, yeah, you certainly could ask that.
Again, goes with what you said when they went to the court. Well, I forgot But when you appeal it, you present these things, but you didn't present them to us.
Yeah.
Yes.
You didn't present them to us because we spoke on that,
Mhm.
you know, so.
There maybe, I remember one case, not that I handled, where a court remanded it to a BCA just because it felt like, it wasn't going to hear new evidence. That was the role of the BCA. Then if the BCA decision was appealed again, then the court would hear it. So,
Yeah, can I ask a question? About the inverse of that, and that is the BZA gives but they approve it or disapprove it.
Uh-huh.
Do they, or should they cite the reason why they're making this statement?
Yes.
yes. And that's a very good thing that you should do as a BZA. I was spoiled for several years by the Prince William BZA because one of the members worked in the Solicitor General's office up in DC. And they would just turn to him and say, well, would you please just organize our reasons? And he'd come out with something that sounded like a legal brief. It was wonderful. I mean, courts were spoiled too. You're not required to do that, but it is very useful for the court in evaluating your decision, in knowing the reasons for it and not just, yeah, we agree. No, we don't agree. So,
Okay, so it's
yes.
not mandatory. I wish it were mandatory because that's what I always do.
It's strongly preferred.
Okay.
Strongly preferred. That's right. Okay, let's go to, and I think there may be one area, my brain's doing a little bit of glitch on this where it may be mandatory, so I'll come back to that. Mr. Thorne, doing the job of the BZA member. Next one, please. And I'll see if I can just pick this up a little bit so that too long. Procedural considerations, really important things. One of the strongest things, one of the key things that a court looks at in terms of evaluating BZA decisions is, have you followed the procedures both under the law and not, it doesn't hurt a decision if you don't follow your internal procedures, but it undermines it when you don't. So if you have a bylaw provision and then you ignore it, then that's certainly the other side who's opposing your decision will raise up. But following the statutory procedural requirements is very, very, very important to courts. It's very important, Mr. Borker, you may know, with respect to land use decisions generally. And it remains the case with the BZA. So you got to meet the notice requirements. That means you got to make sure you have the public hearing requirements. The public hearing is held appropriate time when it's in advance of when it's scheduled. Always think it's a good idea to have a copy of the ad or something from the paper showing that was done. That would be something we'd include if we went up to court, but meeting those notice requirements, following the Freedom of Information Act with respect to conducting your meetings in public, all of those requirements, following the ex parte requirements, giving equal time in hearing to both staff and the applicant, and that is required by law. They don't have to each take all of the time, but, and you can even set the amount of time you're willing to hear it. I wouldn't set it like you have 2 minutes.
Right.
But you can set a reasonable time. We're going to give a half hour to each side. We're going to give 50, and we'll be glad to take written communications in advance as part of your reports. You have to state the basis for BZA decision and a motion. Again, I think that's a wonderful idea. I believe, and I'm thinking that there's one requirement actually in there, Mr. Thornton, you have me thinking about, I hadn't thought about it for a while, whether it was a legal requirement, because I always encourage it, but there may well be a requirement in the statute to state it. And I'll see if I can find that later to make sure that I guide you in that regard.
Appreciate it.
And then don't attempt to make legislative decisions if you don't have the authority. Next one, please.
Real quick, the the notice requirement, that's generally done by the ZA.
That's
So-
correct. Yes, yes. But, you know,
I mean, we can question him regarding
that's correct.
how effective he was.
And yeah, and you want to make it, I would say that's why sometimes including a copy of the ad if it's available, not always easy to get some of these ads, as Nick and I know from the paper, but allows with a certification on it, but allows you all to know that everything's been properly advertised.
I noticed within the procedural considerations,
Mhm.
there is no parliamentary procedural consideration.
That is correct, yeah.
And
Yes.
sometimes those get in the way of actually participating because you get these junk ballots. Anyway,
It could or could not. It depends on how it's applied. Yeah, so I know you wanted to talk about parliamentary, Mr. Thornton, and we may if we have a chance at
I
the end.
was hoping we talk more about this.
Okay.
parliamentary.
We can talk about that a little bit later. I'm gonna check that. So I don't leave my book here. Let's turn to, we're on bylaws now. Not required, but desirable. They can be helpful in meeting the procedural requirements of the law. I note that some BZAs don't really have staff across the state. And so the bylaws are really important to just as a kind of a checklist. And then it's also important to have parties that come before you know how you conduct business and what to expect. And so it's useful in that regard because, you know, usually they come to Nick and Nick can just say, here's the bylaws. This is what you can expect in terms of how business is going to be conducted. And we'll have mention of the ex-parte communications, which again, we have to appreciate the fact that most members of the public, particularly if they don't have counsel, would not be familiar with a lot of these requirements. Even though they're not held to a different standard, it's just they wouldn't be familiar. Next one, please. Okay. You can, if you set up rules, you can make or rescind them later or change them. You have to conduct your business by majority vote. That's a matter of FOIA. That's not a bylaw issue. Putting in, some BZAs do have, Fairfax, for example, and it's not the only one, but have all of the process as to how the public hearing will be conducted. You have to keep a full public record and they're open for inspection. But you do have to update them if you have bylaws. It's not any good. Years ago, I updated the Fairfax County bylaws, which maybe will make you feel a little better. They were really out of date at the time. So, but it's important to keep them updated.
Question. The bylaws that are created by the BZA, are they mandatory that they be approved by the town council?
No. But some town councils, I'm saying no, and Nick's not here to check me on it as to whether there's a specific requirement in Dumfries. Some town councils, some other governing bodies do require the governing body's approval of bylaws by various entities. I do not recollect that being in Dumfries, but.
In a charter town, they would have more leeway in that decision, yes? No.
Well, I don't even know that it's an issue of a charter. I think it's a preference by the governing body. I do not recall that. But that's one I'll put in my checklist to look at. Next one, please. We talked about public notice. If the notice is not followed according to statute, then it's very likely your action, if challenged, is going to be overturned. Just count on it. That's where the courts are. They don't like fudging on that. Next slide, please. So things that maybe you haven't had to think about because maybe you've been fortunate enough not to have hearings that fill a whole room. But will reporters be allowed to tape or photograph the hearing? The answer should be yes, but you may, if you had a big hearing, you would ask them to be in a particular location. And we did that once for the planning commission matter. in another jurisdiction where there were 400 people and lots of reporters. We said, here's your designated area. And they were fine. Talked about it with them in advance. Should documents and other evidence be submitted and exchanged between the parties? If so, how many copies? I definitely think the answer is that they should be exchanged in advance so everybody knows what's going on. Now that there's a requirement that the other side get it within 3 business days, you're assuring that. Is there any exhibit labeling requirements? Could be a challenge if you have a lot of exhibits that somebody brings in. Or you may want to just have designate one member of the board to actually go through a number a particular way if Nick's really involved in the public hearing. Or you just ask the parties to label in advance the hearing started. So those are the kind of things where maybe if you're expecting a really big public hearing with a lot of documents, you can, sorry, now it tells me I've been an hour. You can send the notice out in advance that this is how you want to plan on conducting it. But you don't want to be inconsistent on how you're doing this, because then people will come before you and they say, well, that didn't happen in somebody else's case. And so you have to be careful not to say, well, that was a really big hearing and yours is not a big hearing.
Oh, yeah.
So anyway, that bylaws can be helpful in that regard. We've had BZA hearings where people have brought in signs. The Wisconsin cheeseheads, those used to be, other types of stuff. And that's something that can be managed in advance if that's being expected. I'm not telling you all that you're likely to have that. Ensure that the staff report is available to the public the time the BZA receives it. That's something that Nick would take care of. Is there going to be an advanced sign-up sheet? If you're having a lot of people that are attending, you're going to have a sign-up sheet for them to come in so that you all don't need to keep track of what their address is or what other information you want. One thing to keep in mind is that now some people get nervous about giving out their address publicly. So you might default to something like either you're a resident of the town or you're not a resident of the town. You can think about that more, but.
So is that something that we are obligated to do in terms of each time someone comes up? And if so, wouldn't it perhaps be more practical to put it up on the website so that they could put whatever information they had to give?
I don't think they want to put it on the website.
Not the information.
Oh, you could do it that way. You should think about what sort of general procedures you're going to have and whether you think you need them. If it's a simple one and you want to adopt as a BCA that you're not going to ask what street people live on or their precise address, but you're going to ask whether they're a town resident or not. The chair can indicate that at the beginning of please step up to the podium, give us your name and whether you're a town resident but you can still ask people to get their address, but you just realize that some people don't want to state it.
Okay.
So it's out there publicly.
Okay.
With some good reason, unrelated to.
And the biggest thing there is that you want to make sure that they are a town resident or not.
That's something you might reasonably want to know.
Yeah.
Yes. Okay, whether it's a separate view of the property apart from the hearing. Pretty key thing. Used to be that BZA members or planning commission members might just go out to a site, maybe even with one of the parties in the matter being there. That's one person could do that. With your ex parte requirements now, you have a problem. Sometimes it's very useful for you to view the site. And so what you need to do is announce it in advance when you're going out and go take a view. And because it's likely to be more than 2 of you, and therefore FOIA is applicable and it's considered a meeting. So you will want to be careful in that regard. And Nick can help you in terms of giving the notice for that to occur.
But you can do it singularly. as.
You could, yes, but if you're going to, talking to the property owner who's got,
Talking, just looking.
yeah, then you can do that. And sometimes it's just an issue of drive-by. You don't need to really get onto the property. You do have to be careful, though, if you're going to go walking on a property. One good reason for notice, maybe in working through Nick in advance or the other party, is to make sure you have permission to be on the property, so you're not trespassing. Sometimes people don't think about that, even though they want a variance or they're appealing something. They may not have thought that they really wanted anybody showing up on their land unannounced. So bear that in mind for your own safety as well, not just for you. Okay, next, Nick, can I ask you this question since we're on? Does the council require that it approve the bylaws of the BZA?
Yes.
Okay, thank you. Nick's clarified that. That one's one. Thank you for doing that. I could not recall. Okay, next slide, please. Other pre-hearing details. If you think you have a conflict under the Virginia Conflicts of Interest Act, I have in here county attorney. I should put in there town attorney too. But we would have to check that out. Check it out with talking to the people down at the Coya Council. And it's better to know that way in advance because it does not instill public confidence when a member of a governing body or commission or the BZA says the night of the hearing, oh, I think maybe I've got a problem here. And that just does, the public sitting there is going, what's going on? And it may be a matter that ends up there's no conflict at all. And now you've sort of undermined the credibility of the body. So bear that in mind. It's early and often ask. On legal questions, you should think about how you handle things such as procedural violation claims. You know, how are you going to sort that out? How are you going to sort out that somebody claims the ordinance is unconstitutional? That's not your issue. You can't determine an ordinance is unconstitutional. So you may direct them to go some other course or any other legal questions. Since you don't normally have legal counsel here, those are things that maybe will come to mind and go, I don't know what to do about that. On the notice issues, you may well be able to turn to either the file or the staff report or to Nick, and they can advise you that this is the notice that's been given. It may be that if you have two attorneys representing parties that you say to them, we would like to hear your opinion, each one of you, as to what your opinion is as to these legal issues. And then you can make a decision. In rare cases, although the General Assembly this year gave a bit more encouragement to governing bodies, you can go to the town council and say, we need to hire an attorney to advise us. This matter is important. Council doesn't have to do it, but it's now been codified that you can ask, which I always thought you could ask anyway. But when I spoke to one of the legislators about it, they were quite overjoyed that that was recognized now, that it was okay for the BZA to go and ask for legal counsel. So next slide, please. I think we've talked through these. Next slide, please. One thing useful, chairman should summarize the relevant procedures at the beginning of the meeting. That's so everybody knows what the rules are. That's a good way to do it. And I've gone through and put a couple of things. You can ask to have oaths administered. You could administer oaths to the people testifying before you. Whether or not you choose to do that is up to you. Whether you're going to allow cross-examination. When you have two attorneys, you know, on each side, whether you're going to allow them to do direct cross-examination or whether you're going to say, I'll be glad to entertain any question and then direct it to the party as opposed to the, I call it in-your-face cross-examination. Sometimes it's a better way of controlling the conduct of the hearing, but that's your choice. You had mentioned earlier, Mr. Tony, issues of hearsay. Maybe you were talking more about just oral testimony. Do you want to accept that or not? So you have to be careful on putting too narrow constraints on that, but you could say the BZA prefers to have whatever written evidence that you have provided. We'll listen to whatever you have to say, but we really would like you to provide documentation. And we talked earlier about labeling exhibits. Next one, please. I think we missed one, but could we go back one, please, to 37? Okay, no? Okay,
I think we're on 36 right now.
36.
I did, oh, did I miss 36? Oh, I did, I apologize, I've got two on a page. Thank you very much for keeping me on track, Ricky and gentlemen. Chair's got the burden of making sure that the hearing proceeds in an orderly manner. Normally, no problems here, but sometimes it can be a bit of a pain. The rest of the members of the BZA need to be supportive if you're in a potentially disruptive situation of the chair trying to keep the meeting on track. You have to make all decisions in public. That's sort of obvious anyway under FOIA. If you're going to draft a written opinion, make sure who's going to write it and how it will be done and when it will be brought back. That could be a big issue if you're not meeting very frequently. You want to make sure that things are handled in a timely way. And you set a deadline because you have the 90-day outside time requirement. So bearing all of that in mind.
Is writing a legal opinion the norm or?
No. And I would hesitate to call a legal opinion so much as opinion of the BZA.
Opinion.
Yes, so you may somebody may cite law on it, you might, but or you can ask for briefs from the party's attorneys, but again, you've got that 90-day time period. And you also, I will tell you just from experience and probably having violated it many times, you probably want to be clear what you mean by brief, as in page numbers. Otherwise, you could get a quite sizable document depending on the issue and the attorneys involved. Or parties involved. I've actually seen people without counsel that have written quite a lot. Next one, please. Obvious, care about those things which the court cares about, because the court's going to be giving you the scrutiny. Follow all the procedural requirements, all the legal requirements. Absolutely critical. In fact, I would say it's almost more critical than the substantive decision you make in terms of what the court's looking at. Next slide. Should you be making findings of fact? Thank you. My slide has saved me from my loss of memory on this. The answer is that they're not required, but the circuit court may have a hard time figuring out what you did because oftentimes when there are problems in a court reviewing a BZA transcript, they have comments from various members of the BZA. And then somebody says, motion to approve, second, voted on. So the question is, whose comments was the BZA most agreeing with? Or were they any of the comments that were made, and was it some other reason? So my view is it's better to set forth your findings. When you do the return on writ of certiorari, which usually ends up being the secretary to the BZA does it, you have to set forth the pertinent facts. It makes it very hard for the zoning administrator and the town attorney, you usually end up doing this, to set forth pertinent facts if we don't know what were pertinent facts for you all. So that's where it is, again, helpful. Even, you don't make formal findings of fact, you talk about the key facts that were important to the matter and why the decision was made. They don't have to be really hard, and I put my sort of example in here. The BZA finds blank because of blank. Okay, so don't think you have to write a legal brief. Don't be nervous that you've not done the citation right to something. What's the court's more concerned about is what is the gist of your decision and why are you making it? And then, as I mentioned here, lowest common denominator. You may not want to try to cover every fact in the case because You all may not agree on every fact being important. There may be only 2 or 3 facts that everybody agrees are the important reasons for making a decision. Okay. So go to lowest common denominator in that sense. Next page. I think okay. Generally, the hearing is recorded, and generally the court does not listen to the hearings. Courts hate listening to these hearings because they don't even get to see your faces. They're listening to, and they don't know who's talking. And the hearing quality is generally good nowadays with taping, but it's very annoying to listen to when you have no idea who's talking. So generally the court looks at a transcript. If you have a matter that is going to be one that's likely going to be appealed, then my thought, and you may even recall recently on one matter in the last year or two, where the other side brought a court reporter to make a transcript at the time instead of doing it from a recording, because as hard as it is for all of us to listen to this, for a court reporter who usually is not doing land use work, it's very hard and to put together and to follow who's saying what when. So I have also brought in court reporters from time to time on matters just to make sure you had a good transcript at the front end and didn't have to worry about it later. Avoid extraneous matters. And, things come up that are not really relevant, but people start talking about it and you add it to your findings of fact or your final decision. And it's like, why? That was not important. We don't need to do that. Next one, please. Appeals, the controversial hearing. You don't have controversy here, so we don't need to worry about this slide, but we will plan it in advance. Okay. But there have been lots of BZAs that have gotten surprised with a controversial hearing, and then you worry about things about security, you worry about process, you worry about, who can everybody get heard reasonably, you worry about how long are you going to be sitting here before the public hearing's over. We'll hopefully can anticipate that, and if it ever happens. Next one. Appeals to the circuit court. Again, the focus is on person can appeal if they are aggrieved. Or it can be an aggrieved taxpayer, or interesting, it can be any officer, department, board, or bureau of a locality. And candidly, I haven't seen that other than a zoning administrator taking an appeal up. There are a set of decisions from some time ago in Fairfax County, which tends to make a lot of the law just because it's bigger, but in which the zoning administrator and the board of supervisors were paired off against each other on BCA matters. The review of the decision is of the decision, not of the BZA. So even though the BZA appears in the style of the proceeding when it's appealed to circuit court, you do not need counsel in it. You do not need to appear in it. It doesn't mean I haven't heard on occasion where there's been a subpoena for a member of the BZA, but you should not, because it's a decision of the board. It's not a decision of an individual. So you wouldn't normally get legal counsel in that regard. Next one, please. You have to file the record of proceedings, which is called the response to writ of certiorari. And Nick and I have worked on one of those before, actually in the last 2 years. And we package up all your documents. We package up the recording if there's no transcript, and that goes to the circuit court. Next one, please. The findings and conclusions of the BZA on questions of fact are presumed correct. This is where it gets a little thorny. It's preponderance standard to overcome the BZA. I use my sort of balancing act. On a variance, the petitioner can rebut the BZA's action by showing by a preponderance. So that's what you keep hearing. They would have to show things like you applied erroneous principles of law, if you used your discretion was plainly wrong, or that you violated the intent and purpose of the zoning ordinance. And then in circuit court, parties can introduce evidence, additional evidence. I have tried to, on a couple of occasions, get the court to prohibit additional evidence. And I've largely not been successful, even though I've been successful on the outcome of the case. That's where I think that if the BZA says, have you given us all of the evidence at your hearing, that the court may be more inclined to not allow new evidence in at that point. Reports, next one, please. Reports to, I have BOS up here, I apologize. It should be reports to the council. And annual report is required by statute. This is where if you think there's an issue that the town council should know about, you might use this as a vehicle to just say, we think you ought to look at this. Not just, we handled 4 variance cases and 3 appeals, and that's what we did. It might be, you know, if there is something that's useful. I don't think, and I know that boards of supervisors and city councils and probably town councils don't want you to be writing an epic about my life as a BZA member. Rather, I think it can be a useful, you know, at times when there's something you feel like you need to communicate to them.
Who would assume the responsibility of
Usually,
authorizing that? I mean, on a,
You would do it as a BZA as a whole, and then it would go in the annual report. You could write outside of the annual report, but there's no requirement for you to be on a constant reporting basis to the town council. And my guess is they're just as happy not to hear from you. I don't mean that in a negative way. It's just you are charged to do certain things and they expect you will do them. So,
here it's once a year.
okay. Next one, please. Couple things. Remember that your actions are critical to the integrity of the zoning ordinance. That's important. Sometimes you wonder, why am I doing this? What you do is critical to the integrity of the zoning ordinance. So bear that in mind. Because your actions refer to the zoning ordinance, what you do can either support the zoning ordinance or it can undermine it. Again, important. You don't have the power to rezone property. Or, as I said earlier, to base your decisions on what you think is for the good of community. That's the job of the town council with the recommendation of the planning commission. With my one caveat that if you're seeing something that is a constant problem, you might want to let the governing body know about it. Follow, not make law. Next one, please. I'm not going to go through all of these, but because I already mentioned the one about the ability to ask for legal counsel. It also includes employing secretaries, clerks, consultants, et cetera. Doesn't require the governing body to give them to you. Just says you can ask. On electronic meetings, this bill is really not applicable to the BZA. It's only useful to know that it actually calls out the BZA as one of those groups that can't have limited all virtual meetings when there is no emergency. So the General Assembly allowed some other groups to actually have virtual meetings when there is no emergency. It was new legislation this year. You're not one of them.
Is there a formula or a list of what constitutes an emergency?
Yes, that's set forth in the statute. We've got it. Well, the governor has to declare emergency, or the county, or the town. And then you go through a host of hoops to determine whether or not you can go to a virtual meeting. Yes. Yes, that's set forth in statute. Okay, I'm just going to touch on a couple of cases just to, you can read through them. Next slide, please. Next slide. Marsh versus Roanoke County. This was an issue as to whether The governing body was required to be named as a necessary party to proceedings in circuit court. And in that case, the court said the answer was yes, because of the nature of the matter and a review of a BZA decision. So it was a procedural naming of who was a party. Next one, please. This one is had to deal with a residential treatment center. This got into the issue of standing. And next slide, please. And then the court went through the Fairfax zoning ordinance and a number of other things, and then the property was sold. So bottom line, after all of that, was that the appeal was dismissed as moot because the property was sold. So different owners. Again, much ado about nothing, but I tried to pull out just cases that dealt with BZAs. There weren't many, and I thought you might find them interesting. Next one, please. Bragg Hill. My firm worked on this case in part. It was pretty convoluted. It talks a lot about vested rights law. And so if you're interested in looking at a recent case in which the court has considered the issue of vested rights, this is one. And the court found in that case that the developer did not have vested rights. But the case gets really convoluted because the property at one point, as I recollect, was inside Spotsylvania County, and then the boundary line was moved. It was inside the city of Fredericksburg. So it gets mixed up in two different zonings. Next one. The Con case is, again, a vested rights case. In that case, the Supreme Court found that there was a vested right to an originally illegal use after the owners had paid taxes on that building for 15 years. Kind of an interesting dynamic. The case gets more convoluted. Next slide, please. More convoluted, but you will find it interesting. But the key thing for the court in that case was the payment of taxes on what was alleged to be a grandfathered use. Next one. This one is closer to home, and actually, I think I worked on zoning violations on this property when I was an assistant county attorney, so that was long ago. But this is the Archie property in Prince William County, and it's an automobile graveyard. And the bottom line is that the circuit court had found that there was a pre-existing non-conforming use that had not been abandoned, and the Supreme Court upheld that decision. But I thought that was interesting just from the standpoint of a local case. So that's my end. I think next slide. Done. And I'm a little longer than I had planned on being. I apologize. But I'm glad to answer any additional questions that you might have.
Just one question is if, let's say it's a family member has the property and I feel I need to, say,
Recuse.
excuse myself. Would I be able to sit and listen to the case but not vote, or do I need to leave? the room?
That's a good question. First, just because you have a family member doesn't necessarily mean you have a conflict. There's some very specific requirements, and if you want a tutorial on the conflict of interest tax someday, I can come in and do that. But it's based on usually on residency in the home, support, and monetary connections.
Okay.
And then it lists several people that are considered to be within that purview. So that's first thing. Second thing is you then determine whether the matter relates only to your particular family member or whether they are a group. And if they're like 4,
Okay.
then it's a group. And then you get into a determination as to whether or not there has to be an abstention or whether you can make a disclosure of the conflict and say can fairly and objectively vote on the matter in the public interest, in which case you would be able to do that. There are forms for doing this. And if you ever think you have a conflict, then let Nick know and we can kind of manage put you on the right course to getting that sorted out and those particular forms filed, because they have to be filed in the public record. And any conflict announced at the meeting. So it's not just filing it, you have to say it verbally. If you're conflicted out, and you have to recuse or abstain, then you can certainly listen to matter, but you are completely conflicted out.
Okay.
You cannot participate unless it is, well, you could participate and come in and speak on the matter in a public hearing.
Okay.
And participate that way. I would caution against that unless it's your property, because it tends to affect the sense of integrity of the group as a whole.
Right.
But you would then not go to your chair, and I'm saying you just because you mentioned it.
Right.
You would, I think, and the way I've seen it best done is for the person affected by the conflict to sit out in the audience. So it makes it clear they're not part of the action. If there were to be a closed meeting, which you rarely have, you couldn't go to the closed meeting. You couldn't say to Nick, I think X, Y, and Z, and have those communications. You can't talk to your colleagues about the matter. You are completely out of it, completely. So the caveat would be that if you're going to participate as on the matter, because let's say it's your property, then all the things you would do as if you were not a member of the BZA.
Okay.
Okay. All the ex parte communications, all of that stuff has to be done as if you're non-BZA member. I was going to say just a regular citizen, but
Yeah.
so,
Okay.
yeah.
Thanks.
No, that's important thing, because there used to be confusion, I think, by some people that, oh, I could still go talk to the planning director. I could talk to the zoning administrator. I could do this. I could do that. The answer is no, you can't. If you recused yourself, you cannot do it.
Give him a nice watch.
Oh,
Okay. Anything else, gentlemen?
very good.
As I told Mr. Thorne in the beginning, if there happen to be some other follow-up matters, I think we covered all of the things I was going to check on just as we went through then let Nick know if I don't want to have like a lot of intermittent communications just because it confuses the role that I have, which is not as counsel for the BZA, but as counsel for the town and for the zoning administrator. And I don't want that to create issues for everybody later on. But if a training like this, which I think is, it's the kind of training I've given it to mixed groups that have people that are non officials in it, I'm more than willing to do that. Thank you. Thank you for your service. I appreciate it. As you have worked long hours and then you come here and you work more long hours. And but it's been nice to talk with you tonight.
We appreciate you as well.
Yeah. Okay, continue on the agenda, open forum. Does anyone have anything they'd like to add or whatever besides great training? We appreciate your time.
Make a
was
motion that we adjourn.
Anything? Okay. Second, any discussion? All in favor of adjourning?
Aye.
Opposed? All right. Thanks again for, arranging for this. This was very good. It's good review and everything.